All right, let's get started, and thank you for being here. I want to open with a number that sounds too small to be worth a webinar. 10 minutes, maybe 12. The amount of time a worker spends standing in a line, getting screened, badging in, or pulling on safety gear before their shift officially begins. On a single timesheet, that's nothing. It rounds to 0. Most of us have walked past that 10 minutes 1,000 times and never thought about it. Here's the problem. That 10 minutes doesn't stay small. You multiply it by every shift that worker has in a year, then by every hourly worker on that site, then across a few years of history. And somewhere in that math, a number that looked like a rounding error turns into the kind of exposure that lands on a CFO's desk and an outside counsel's invoice. That's what this session is about. On March 19th of this year, the Illinois Supreme Court handed down a decision in a case called Johnson versus Amazon.com Services, and it changed how Illinois employers have to think about exactly that 10 minutes, the time before the clock and after the clock. I'm going to walk you through what actually happened in this case, from the day it was filed to the day the court ruled. I'll explain, in plain English, why Illinois law treats this differently than federal law, why your federal compliance program may not protect you here, which kinds of workplaces are most exposed, and most importantly, what you and your teams should be doing about it. We'll keep it practical. This is a working session, not a law school lecture. One quick ground rule before we dive in. I'm not your lawyer, and nothing I say today is legal advice for your specific situation. Think of this as a map of the risk and a starting checklist. The final calls, especially before you change any pay practice, should go through qualified Illinois employment counsel. With that said, let's get into it. I want to start with the business risk, not the legal history, because that's the part that should drive what you do this quarter. It would be easy to file this case under interesting legal development, circulate to the team, move on. I'd encourage you to resist that instinct. This isn't a footnote. It's a shift in how the paid workday gets measured for non-exempt employees at your Illinois locations. And once you see how it works, you'll understand why it's worth your attention now, not after a demand letter shows up. So let's talk about why. Here's the single sentence I'd ask you to take away from this whole section, and it's on the screen. Small amounts of unpaid pre-shift or post-shift time can become major exposure when you multiply them across large hourly workforces, repeated shifts, overtime weeks, and class action claims. Let me make that concrete, because the math is the whole story. Picture a distribution center with, say, 300 hourly associates. Each of them spends roughly 10 minutes a day in a required screening or entry process before they can clock in. Each works around 250 shifts a year. 10 minutes times 250 shifts times 300 people, that's already over 12,000 hours a year of time somebody might argue should have been paid. Now, stretch that back across the look-back window the law allows and add overtime, because some of those minutes were the minutes that pushed people past 40 hours in a week. The overtime piece matters a lot, and we'll come back to it. That's the mechanism. A few unrecorded minutes look trivial on one timesheet, and they look like systemic liability the moment you aggregate them across a workforce and a class period. The numbers on this slide are illustrative. I'm not predicting anyone's damages, but they show you why it's only 10 minutes is exactly the wrong way to think about this. The smallness is what makes it dangerous, because nobody's been watching it. And that's why this belongs to HR right now, not to legal 6 months from now. The fix is operational, and operational fixes take lead time. Now, before anyone in HR feels like this just got dropped entirely in their lap, let me reframe it. This is not a problem HR can solve alone, and honestly, HR shouldn't try to. Look at who actually controls the pieces. Operations designs the workflow. They decide whether screening happens before or after the clock. Security runs the checkpoints and the entry process that can sit in front of paid time. Payroll configures how time gets captured, coded, and corrected in the system. Frontline managers set the informal expectations on the floor, and as we'll see, a casual instruction from a supervisor can create off-the-clock work all by itself. HR owns the policy, the audit, and the job of getting all those functions in the same room. And if you're a multi-state employer, there's a sixth player, whoever owns your national timekeeping standard. Because the assumption that one rule fits every state is exactly where this goes wrong. That last point is the bridge into the next part of the session, and it's the one on the screen. Multi-state employers cannot rely on federal wage rules alone. A timekeeping practice that is completely fine under federal law, that would pass an FLSA audit without a blink, can still create real exposure at an Illinois site. Let me show you why. Let's talk about the case itself, because understanding how it got to the Illinois Supreme Court tells you a lot about why the ruling landed the way it did. I'll keep this section accessible. You don't need a law degree to follow it. We'll cover who brought the case, what they were actually complaining about, the legal argument on each side, how it traveled through the courts, and what the court ultimately decided. And I want to spend real time here, because the journey of this case is the clearest way to understand the risk. So here's the story. It starts in March of 2020, at the very beginning of the pandemic. Amazon, like a lot of large employers at that moment, put mandatory COVID-19 health screenings in place at its Illinois fulfillment centers for hourly warehouse workers. Before an hourly associate could start their shift, they had to go through a screening at the facility entrance, a temperature check, and a symptom questionnaire. And here's the operational detail that matters. They were not allowed to clock in until after they'd completed that screening. Workers said the process generally ran 10 to 15 minutes, sometimes longer when lines backed up. And Amazon did not pay them for that time. Now, think about what that looks like physically, because it's a pattern you'll recognize. The worker arrives, they get in line at the entrance, they wait, they get screened, then they walk to the clock and punch in. And only at that point does the company consider them on the clock. Everything before that punch, the arriving, the waiting, the screening, was unpaid. That's the gap you see on the right side of the slide. Steps 1 through 4, unpaid. Step 5, pay begins. Two of those hourly workers, Lisa Johnson and Gail Miller Anderson, brought a lawsuit. They filed it on December 22, 2022, in Cook County Circuit Court. So it started as a state court case. A few weeks later, on February 3, 2023, Amazon removed it to federal court, to the U.S. District Court for the Northern District of Illinois. That removal is why, if you ever see the federal docket, it carries a 2023 number, even though the case was originally filed at the end of 2022. Their core claim was straightforward. That required mandatory pre-shift screening time was work time, and they should have been paid for it, including overtime. Because for some workers, those extra minutes spilled over 40 hours in a week. They brought their claim under two laws at once, the Federal Fair Labor Standards Act and the Illinois Minimum Wage Law. The first round did not go their way. Amazon asked the court to throw the case out, and the company's argument is one you should understand, because it's probably the same assumption baked into a lot of your own pay practices. Amazon pointed to the Federal Portal-to-Portal Act. That's the piece of federal law that lets employers exclude certain preliminary and post-liminary activities from paid time, the stuff employees do before and after their real work, unless it's integral and indispensable to the job. Amazon's position was, screening is preliminary. Federal law lets us exclude it, and the Illinois law should be read the same way as the federal law. And on December 7, 2023, the district court agreed. At that stage, the judge dismissed both the federal and the Illinois claims, and the reasoning is important. The court said that Illinois courts and federal courts frequently analyze these wage claims together, and that when a claim gets dismissed under the federal integral and indispensable standard, the Illinois claim usually goes with it. In other words, the trial court treated Illinois law as if it simply mirrored federal law. That assumption that Illinois follows the federal rule is the exact assumption this whole case turned on. The workers appealed, and that's where it gets interesting. We'll pick up the journey on the next slide. So the workers appealed, and the case goes up to the U.S. Court of Appeals for the Seventh Circuit, the federal appeals court that covers Illinois. The Seventh Circuit held oral argument on September 25, 2024, and then it does something that tells you how genuinely unsettled this question was. It doesn't rule on the merits. Instead, on July 8, 2025, it says, in effect, this is a question of Illinois law, and it's of profound significance to workers and employers in this state. The right people to answer it are the justices of the Illinois Supreme Court. So the federal court formally certified the question to the Illinois Supreme Court and asked them to resolve it. The question was narrow and precise. Does the Illinois minimum wage law incorporate the federal Portal to Portal Act's exclusion for preliminary and post-preliminary activities, or doesn't it? The Illinois Supreme Court agreed to take it up and heard oral argument on January 13, 2026, and this drew a crowd, which tells you how much was at stake. On the workers' side, the Illinois Attorney General and the Illinois Department of Labor, the agency that actually enforces this law, filed a brief saying the wage law does not incorporate that federal exclusion. On the employer side, a coalition filed in support of Amazon, the U.S. Chamber of Commerce, the National Retail Federation, the National Association of Manufacturers, the National Federation of Independent Business, and the major Illinois business associations. When the enforcing agency lines up on one side and the national business community lines up on the other, you know this is consequential. And on March 19, 2026, the Illinois Supreme Court answered the question. The holding is on the screen, and here it is in plain terms. The Illinois minimum wage law does not incorporate the federal Portal to Portal Act's exclusion for preliminary and post-preliminary activities. Where the two laws differ, and on this point they clearly differ, Illinois law stands on its own. The court was careful about the relationship between the two bodies of law. It said Illinois courts can look to federal law for guidance where the statutes are parallel, but where there's a marked difference in the text and the Illinois statute simply doesn't contain that federal carve-out, Illinois law governs. So the practical meaning, the point on the left card, time a non-exempt employee is required to be on the premises can be compensable in Illinois, even in situations where the federal exclusion would have taken it off the clock. Now, here's the part I need you to hear precisely, because it's easy to overstate. The court answered a certified legal question. It did not issue a final damages award, and it did not declare a dollar figure that Amazon now owes. The underlying lawsuit goes back to the federal courts to proceed under the answer the Illinois Supreme Court just gave. So when people say the employees won, what's accurate is this. They won the controlling question of law and on liability. That's the whole game. But the case itself isn't over, and no money has been ordered. Please don't repeat this internally as there's been a verdict, or Amazon has to pay X. That's not where things stand. What's true is that the legal question that decides whether this kind of time is compensable in Illinois was resolved in the workers' favor. I want to slow down on this slide because if you take one conceptual thing away today, it's this comparison. And let me say something clearly upfront because it's the most common point of confusion. This is not a change in federal law. The FLSA didn't change. The Portal to Portal Act didn't change. This is an Illinois state law issue. What changed is our understanding of how broad the Illinois statute is. And it turns out it's broader than the federal one. Look at the two columns side by side. On the federal side, the Portal to Portal Act lets employers exclude many preliminary and post-preliminary activities from paid time. The general rule is that pre-shift and post-shift activity isn't compensable unless it's integral and indispensable to the actual job. So under federal law, walking from the entrance to your workstation, waiting in a line, a routine security check, a lot of that can sit outside paid time. And that's genuinely convenient. It's what lets a national employer run one standard pay practice across all 50 states. On the Illinois side, the wage law reaches all the time an employee is required to be on duty, on the premises, or at a prescribed place of work. And I want you to circle that one word, required, because it's doing all the work. The Illinois statute doesn't contain an express preliminary and postliminary exclusion the way federal law does. So if the activity is mandatory, if the employer requires it, and it happens on the premises, Illinois law may treat it as compensable even in situations where the federal exclusion would have applied. Which means one national pay rule can quietly fail at your Illinois locations. The gap between those two columns, that's your exposure. And here's the uncomfortable truth. Where Illinois is broader, your federal compliance doesn't close that gap. You can be doing everything right under the FLSA and still have an Illinois problem. That's why we're fully FLSA compliant is the right answer to the wrong question. Let me walk this trap through step by step, because it's a reasonable trap to fall into. The assumption goes like this. Our timekeeping policy is federally compliant, so it's compliant everywhere we operate. That sounds responsible. It sounds like exactly what a well-run company would say. Here's the flaw. States are allowed to set wage standards that are more protective than the federal floor, and several do. Illinois just told us it reaches required on-premises time that the federal exclusion would have removed. So the compliant everywhere assumption breaks the moment you cross into a state with a broader standard. And the result is the thing that keeps compliance people up at night. A single national rule can be perfectly correct in most of your states and quietly non-compliant in Illinois, and nobody notices, because the policy looks fine. It passed the audit. It's just the wrong policy for one state. The fix isn't panic, and it isn't a mandate I can hand you from this stage. It's a deliberate, Illinois-specific review of your actual workflows, and then a decision made with counsel about whether to localize your Illinois practice or simply raise your national standard to the more protective rule. Both are legitimate choices, and we'll come back to that decision near the end. The action item on the screen is the simple version. Flag every Illinois worksite for a dedicated timekeeping review. Don't assume the national configuration carries over. Go look. Okay, we've covered the law and the case. Now let's get out of the courtroom and onto the floor, because the gap between the legal principle and your day-to-day operations is where the real work lives. This next stretch is about the practical problems this ruling surfaces, not theory. The systems, the workflows, the managers, and the coordination headaches you're going to run into the moment you start looking. Here's what HR teams are actually wrestling with when they start digging into this. And I'd bet you'll recognize most of these. Your HRIS and payroll systems were configured around federal assumptions. Somebody set them up years ago to capture time the way the FLSA allows, and nobody's revisited it. Your timekeeping is probably fragmented. Different clocks, different vendors, different rules across sites, especially if you've grown by acquisition. Your Illinois sites have their own entry and screening steps that have honestly never been formally mapped. The process lives in people's heads and on the floor, not in a document. Your managers are unsure what even counts as paid time. Payroll corrections, when you find a problem, are heavy lifts. Recalculating historical time is not a 5-minute job. The documentation burden is real. Can you actually prove what was paid and when, going back years? The line between required and voluntary activity is genuinely hard to draw. And none of it gets solved unless HR, payroll, legal, operations, and security are coordinating, which in most organizations they aren't, at least not on this. I know that's a long list, and it can feel overwhelming. So here's the reassuring part. And it's the line on the screen. Most of these are workflow and configuration problems. They're not acts of God. They're fixable, and they're a lot cheaper to fix now than to litigate later. Let me give you the 10 specific risk areas to put in front of your leadership team. I'll go quickly, but I want you to have the full list. Number 1, off the clock pre-shift time, the headline risk, the screening and entry time before the punch. Number 2, overtime miscalculation, and this one's sneaky. When those extra minutes push someone past 40 hours, you don't just owe straight time, you owe overtime on it. Number 3, class or group claims. Wage cases rarely arrive one employee at a time, they arrive as a group. Number 4, retroactive back pay, because the law has a look-back period. Number 5, record-keeping gaps that make it hard to defend yourself even when you did the right thing. Number 6, manager-created liability, the informal come in early instruction. Number 7, the physical placement of the time clock, which can be the entire problem on its own. Number 8, a national policy that fails specifically in Illinois. Number 9, the operational cost of actually fixing this. And number 10, employee relations and trust, because how you handle this is visible to your workforce. Every one of these grows with two variables: how many people and how much time. That's the multiplier again, and the caution on the screen, which I'll keep repeating because it matters. The financial impact here is fact-specific. These are exposures to evaluate against your actual situation, not predictions, not guaranteed losses. The goal is clear-eyed assessment, not alarm. So who should be paying the closest attention? Let's talk about where this risk concentrates. There's a common thread across every high-exposure employer, and once you see it, you'll spot it everywhere. A controlled entry point, a required pre-shift activity, or both. Anything that puts mandatory time in front of the clock. Let me walk the map, and for each one, notice the same pattern repeating. Warehouses, screening lines and entry queues before clock-in, distribution and logistics, gate checks, scanning, staging the operation before the shift formally starts, manufacturing, PPE, tool issue, and pre-shift safety briefings, all of which can happen before the punch, food processing, sanitation, gowning, and hygiene steps that are mandatory and time-consuming by design, healthcare, badge-in, donning protective gear, and shift handoffs, laboratories, controlled access and protective equipment before you ever touch the bench, retail and big box, bag checks and security stops, often on the way out, post-shift, secure offices, security and controlled access at the door, data centers, multi-layer screening before you reach a workstation, and hybrid worksites, app-based or security screening on the days people come in. Different industries, same shape. There is a mandatory, employer-controlled activity sitting on one side or the other of the time clock. So here's the first thing to check, and it's identical for every one of these workplace types. It's the action item on the screen. Is there a required activity or a controlled entry that happens before the employee clocks in? If the answer is yes, that activity goes on your audit list. That's the screen you run on every site. And remember, whether any specific activity is ultimately compensable depends on the facts. The point isn't to assume the worst, it's to know where to look. This slide is the one I put on the wall because it reframes the whole issue. This is not only a legal problem, it's a workflow design problem. And that's actually good news because workflows are things you can redesign. Look at the real employee journey across the top. Parking lot, entry, security or screening, PPE or tools, then the time clock, then work begins. Here's the rule, and it's simple. Wherever the clock sits after a required step, that required step is unpaid time. Everything to the left of the clock on this diagram is required activity that this particular layout leaves unpaid. Move the clock or change when it captures time, and you change the answer. Let me read you the common breakdowns, because these are the specific things to go look for. A time clock that's physically located after the security or screening checkpoint. Employees waiting in entry lines before they can clock in. PPE, tool, or equipment pickup that happens before clock in. A required system or app login before the clock starts. Mandatory pre-shift briefings. Post-shift bag checks. Equipment return after clockout. Shutdown procedures after the punch, and badge access logs that don't match the payroll records, which, by the way, is one of the most revealing things you can check, and we'll come back to it. Every one of these is a design decision someone made, often years ago, usually for a completely sensible operational reason, which means every one of them is a design decision you can revisit. Let's make all of this concrete. I'm going to walk you through 6 scenarios. These are realistic, composite situations, not any specific employer, and they're built to be ones your sites will recognize immediately. For each, I'll tell you what happened, where the risk shows up, what HR should ask, and what to go review. Listen for your own operation in these. Scenario 1. The warehouse screening line. Employees arrive before their shift starts. They wait in a required entry or screening line, and they clock in only after they've completed it. Where's the risk? All that required waiting and screening time before the punch is sitting unrecorded. What should HR ask? When does pay actually begin relative to that screening line? And how long is the typical wait on a normal day and on a bad day? And what do you review? The clock placement, the real queue times, not the theoretical ones, and whether that screening is genuinely employer required. This is the Johnson fact pattern, almost exactly. If this is your operation, this is the one to look at first. Scenario 2. Manufacturing PPE pickup. Employees have to collect their PPE, their tools, or their safety gear before they're allowed to clock in. Where's the risk? That mandatory gear pickup is happening on unpaid time. And depending on the facts, specialized required gear can be the kind of thing that's integral to the job. What should HR ask? Is the PPE pickup actually required before clock-in? And is it specialized, employer-mandated equipment, as opposed to something the worker could grab on their own time? And what do you review? The gear issue process, where the clock sits relative to the equipment room, and the whole pre-shift sequence. Again, whether it's compensable depends on the specifics, but you can't make that call until you've mapped it. Scenario 3. The retail bag check. This one flips to the back end of the shift. Employees clock out, and then they wait for a required bag or security check before they can leave the building. Where's the risk? That post-shift waiting and inspection time is off the clock. They've already punched out, but they're not free to go. What should HR ask? Are those exit checks mandatory? And how long are people actually waiting after they clock out? And what do you review? The clock out point versus the actual exit location, and real measured wait times, especially at shift change when everyone's leaving at once. Scenario 4. Secure office badge entry. Employees pass through security and controlled access before they ever reach the time clock. Where's the risk? Those required entry and access steps are happening before pay begins. What should HR ask? How far is the clock from the secured entrance? And is that access step genuinely required? And what do you review? Here's a powerful one. Compare the badge-in logs against the clock-in times. If your badge data shows someone entered the secured facility at 6:48 and your payroll shows them clocking in at 7, you've just found your gap in the data in black and white. Scenario 5. The hybrid on-site day. A lot of people assume hybrid work makes this go away. It doesn't. On the days hybrid employees come into the office, they may have to complete required app-based or security screening before they can access the workplace. And that's the same pre-clock exposure as a full-time site, just less visible because it's intermittent. What should HR ask? On in-office days, is screening required before access? And is that time being captured at all? And what do you review? The on-site entry steps and how hybrid time gets recorded specifically on those days, which is often an afterthought in hybrid timekeeping setups. Scenario 6, and this is the one I'd circle because it's the most common and the most overlooked. The manager early arrival instruction. A supervisor tells the hourly team, be here 10 or 15 minutes early so we can hit the ground running and start exactly on time. Said with the best intentions, they just want a smooth shift. But that time never gets recorded. Where's the risk? An informal instruction just created off-the-clock work that your records will never show, and that your payroll system has no idea exists. What should HR ask? Are managers asking staff to arrive early, unpaid? And is that time being recorded anywhere? And what do you review? Manager practices, scheduling expectations, and the gap between when people actually start and when the record says they started. This scenario is the bridge to a section we'll get to shortly, because this isn't a policy problem. It's a leadership on the floor problem. Let's talk honestly about exposure. And I'm going to be deliberately careful with my words here because precision matters. The categories are on the screen. Unpaid wage claims for the time itself. Overtime miscalculation. Again, those extra minutes crossing 40 hours. Class or group claims, because these don't usually come solo. Retroactive back pay across the look-back period. Attorney's fees. Record-keeping exposure. The cost of actually correcting payroll. Litigation defense costs, which you pay whether you win or lose. The strain on employee relations. And reputational risk, especially for consumer-facing brands. On the limitations periods. And this is a point worth getting right. The Illinois minimum wage law carries a 3-year period. There's also a separate Illinois statute, the Wage Payment and Collection Act, that can reach a different window. So please don't flatten this into a single, neat 3-year number in your internal communications. The look-back depends on which claim and which statute, and that's a question for counsel. Here's the posture I'd encourage. Notice the language on the screen. May create risk, should be reviewed, depending on the facts. That's not lawyer hedging for its own sake. That's the correct frame. These are exposures to evaluate carefully against your specific facts, with counsel, not a fixed liability, and not a predicted award. The right response to this slide is a measured audit, not a fire drill. Let's pause and make this interactive, because the best way to internalize this is to ask it about your own operation. I'll throw a few of these up as live polls. Answer honestly. There are no wrong answers in the room. Is your time clock before or after your required entry procedures? Are employees required to complete any task before they clock in? Are your managers asking people to arrive early, unpaid? Does your Illinois site just follow the national timekeeping policy? Can your payroll team actually prove whether waiting time was paid? Do your badge swipe records line up with your payroll records, or do they conflict? Who owns this risk in your organization? HR, payroll, legal, operations, or security? And the one I really want you to sit with. What would you do if an employee filed a claim tomorrow morning? Run 2 or 3 as live polls. Let the room respond. If a few of those made you a little uncomfortable, good. That discomfort is the most useful thing you'll take out of today, because it's telling you exactly where to look first. And notice, when I ask who owns this, the honest answer in most organizations is no one owns it alone, which is precisely the problem we flagged at the start. All right, we've spent enough time on the risk. Let's spend the rest of our time on what to actually do about it. Everything from here is practical. A step-by-step action plan, the manager training piece, the payroll and HRIS fixes, and the multi-state strategy question. The goal is for you to leave this session with a defensible, documented plan, not just a worry. Here's a 7-step plan you can genuinely start this quarter. None of these requires a budget approval to begin. They require attention. Step 1. Map the employee journey. Physically walk it. Parking lot, entry, screening, PPE or tools, workstation, the clock, and work start. Draw it. You can't fix what you haven't mapped. Step 2. Identify the required activities. Go through that map and separate the activities the employer requires from the ones that are genuinely voluntary and personal. That distinction is the heart of the analysis. Step 3. Review the time clock placement. For each required step, ask the simple question: does this happen before or after the punch? Step 4. Fix the time capture. Your options include moving clock in earlier in the journey, adding paid time codes for screening or entry time, building manual adjustment workflows for the gaps, and reconciling badge and access logs against recorded time. Step 5. Train your managers. We're about to spend a whole slide on this because the casual early arrival ask is its own category of risk. Step 6. Coordinate the functions. Get HR, payroll, operations, security, and legal in the same room. HR cannot fix workflow and system configuration alone, and shouldn't have to. And step 7. Document your good faith efforts. Keep records of the audits you ran, the corrections you made, the training you delivered, and the workflow changes you implemented. If this ever becomes a dispute, the story you want to tell is one of a company that found the issue and acted on it. This is the slide I'd make every people manager in your Illinois operations watch. Here's the reframe. A lot of employers don't only have a policy problem, they have a leadership execution problem. You can have a beautiful, fully compliant written policy sitting in a binder and lose all of its protection because of 4 sentences a well-meaning supervisor says on the floor. The riskiest words in this whole topic aren't in your handbook. They're spoken at the start of a shift. Look at the left column. These are the phrases to stop saying. Be here 15 minutes early, but clock in at your scheduled start time. Go through security first, then punch in. Pick up your equipment before your shift starts. Clock out first, then return your tools. Every one of those, said casually to keep a shift running smoothly, creates required work that isn't being recorded. Now the right column, the safer HR-controlled approach. If you genuinely need staff on site early, then record that time as paid. If screening is required before work, capture that time. If equipment pickup is mandatory, treat it as compensable. If there's a required post-shift task, it happens on the clock, and then they clock out. The principle underneath all of it is simple enough to teach in one sentence. If the activity is required, treat it as work time. And the action item on the screen for managers: document the early arrival need rather than handling it informally. Escalate the gray areas to HR or payroll instead of guessing, and never let operational convenience override wage and hour risk. A smoother shift is not worth a class action. Let's get specific about the payroll and HRIS side. And I'll note up front, I'm talking about configuration and workflow here, not endorsing any particular software. The fix is in how you set the system up, not in which vendor's logo is on it. Configure your Illinois timekeeping to actually capture required pre- and post-shift time. Add paid time codes for screening, entry, or waiting time, so there's a clean way to record it. Build solid manual adjustment and missed punch workflows, because exceptions will happen, and you want a defensible process for them. Review your rounding rules. Rounding can quietly shave off required minutes, and at scale, that adds up. Compare your badge and access log data against recorded paid time. That reconciliation is one of the most powerful audit tools you have. Reconcile the rules across your fragmented clocks and vendors, so Illinois sites aren't running on stale defaults. Preserve your audit trails. Keep the record of what changed and why. And the big one: rerun overtime whenever added minutes push a worker over 40 hours, because that overtime recalculation is very often where the real dollars actually are. That last point deserves emphasis. People hear 10 minutes of pre-shift time and think straight time. But if those minutes turn a 40-hour week into a 41-hour week, you're now in overtime territory, and the cost per minute jumps. So overtime isn't a side issue here. It's frequently the main event. For the multi-state employers in the room, this slide is your strategic decision. And there's a real choice to make here. First principle, federal compliance is your floor, not your guarantee. Being FLSA compliant is necessary, but it does not promise you state-by-state compliance. Second, Illinois may need its own workflow because it reaches required on-premises time in a way federal law doesn't. Third, and this is the trap, one national rule can be exactly right in most of your states and wrong in a broader one like Illinois, and it won't announce itself. So you have two legitimate paths. One, localize. Build an Illinois-specific timekeeping practice that accounts for the broader standard. Two, raise the national standard. Some employers decide it's simpler to adopt the most protective rule everywhere rather than maintain a patchwork. That second option trades a little cost for a lot of administrative simplicity and risk reduction. And for some organizations, it's the smarter play. Neither is automatically right. It depends on your footprint, your systems, and your appetite for complexity. Whichever way you lean, do two things first, and they're on the screen. Compare your federal, Illinois, and other state rules side by side before you standardize, and confirm the approach with counsel before you change any pay practice. The simplest administrative answer isn't always the lowest risk one. And this is exactly the kind of decision you want a lawyer's signature on. Let me leave you with the prioritized starting list. This is the Monday morning version, the things to put at the top of the queue. I'd genuinely encourage you to screenshot this slide. Audit your pre-shift and post-shift activities. Review your time clock placement. Identify the required on-premises activities. Check how that time is currently treated in payroll. Review your overtime calculations. Compare badge and access data against payroll records. Train your managers and supervisors. Update your policies and procedures. Create Illinois-specific guidance rather than relying on the national default. Document every corrective step you take. And consult counsel for the final legal decisions. This isn't the entire program, it's the front of the line. Start at the top, work down, and document as you go. I'll close where I think this whole topic really lives. This isn't ultimately about one case, or one company, or one pandemic-era screening practice. Johnson versus Amazon is the headline, but it's not the lesson. The lesson is a single question every Illinois employer should be able to answer about its own operation. Does your real-world workflow match your payroll records? Does the time your people are actually required to be on your premises line up with the time you're actually paying them for? And if the honest answer is, we're not sure, that uncertainty is the work. That's the first thing to go fix. Not because there's a verdict bearing down on you, but because the gap between what happens on your floor and what shows up in your system is precisely where this risk grows quietly until someone points it out. A reminder on the source and the limits of what we covered. The case is Johnson and others versus Amazon.com Services LLC, decided by the Illinois Supreme Court on March 19, 2026. Everything I've shared today is educational. It is not legal advice for your situation. The court answered a certified legal question. It did not issue a final damages award, and the case continues in the federal courts. Whether any specific pre-shift or post-shift activity is compensable depends on the facts. So before you change a single pay practice, talk to qualified Illinois employment counsel. Thank you for spending the hour with me. I know wage and hour compliance isn't anybody's favorite topic, but the employers who get ahead of this one, calmly and methodically, are going to be very glad they did. Let's open it up for questions.